the Divorce Education Series presented by Findling Law. I'm Daniel Findling. In this topic, we're going to discuss alimony. What is alimony and spousal support? Well, the terms are synonymous. They mean the exact same thing. We use the terms interchangeably. If you're talking about alimony, you can also replace that word with the word spousal support. All right, essentially what alimony and spousal support are money. You get money on a monthly basis. We sometimes use the term periodic payments. Typically, it's on a monthly basis. It's for the support of a spouse, a former spouse, in the case of a divorce. All right, so what alimony should be paid? How is it calculated? What factors does the court take into consideration? Well, this is really where we have a legal answer and a practical answer. From a legal standpoint, both case law and statute provide these specific subjective factors that a court must take into consideration, recognizing that every case is unique. What are these factors? Who's at fault for the breakdown of the marriage? The past relations and conduct. It's highly relevant. Did an individual leave another individual under maybe situations that are less than flattering? Maybe that is relevant in terms of an alimony award. Should that individual be rewarded, for lack of a better term, for their wrongful conduct? The length of the party's marriage. It's clear that the longer a marriage is, the greater likelihood that alimony would be awarded. Michigan's more of a rehabilitative alimony state. That is, we want to put an individual in a position so that they can continue on their own without being a dependent spouse. Your ability to work is really relevant as well. Have you been out of the workforce for 20 or 30 years? That would increase your likelihood of getting alimony. Or are you making $180,000 a year and your spouse is making $300,000 a year? Maybe alimony isn't really likely in that case. With the party's ability to work, they're making a good living as it is. All right, the property that's awarded. Now, think about this. If you're an ultra-wealthy individual, I recognize that most people listening to this presentation may not fit in this situation. But if you're an ultra-wealthy individual and you got $5 million in assets and you're making 5% in the market on that asset, you're at $250,000 a year. So a court's going to look at, well, maybe instead of alimony for maybe someone of more modest means, we're giving them the house with $150,000 in equity, and we're not awarding alimony. So part of this sort of trade-off between alimony and property division always takes place. The source and the amount of property awarded to the parties is relevant. The age of the parties, the older you are, the closer that you are to retirement, the less likely maybe that you have the ability to work. We see some crossover with the ability to work. Okay, the ability to pay. What are the incomes of the parties? Okay, is there a disparity of income? Do you have enough cash flow after satisfying debt to pay alimony or spousal support? What's your situation? This is really a wishy-washy legal term. What are your present situation? The needs of the parties. Health of the parties. Are you incapable of working because of poor health? Are you in relatively good health, but you just have an unexercised ability to earn income? In that instance, maybe a court would say, here's an individual with good health, he has a good education, or she has a good education, chooses not to work. Alimony or spousal support would be less likely under those facts. The standard of living. Have you been living life as simple means, even though you have a lot of money? Well, you should continue to live life as simple means. You shouldn't be rewarded just because you're getting divorced. And the alternative, if you've been living a lifestyle that's maybe even above your needs, courts want you to maintain that lifestyle, at least for a short period of time. Whether or not you're paying child support to another party or alimony to another spouse is highly relevant. So these subjective factors, and there's some others, but at least from a statutory standpoint, here are the factors, are really the restrictions that are put on a court saying, okay, award alimony, look at these, do what you think is fair, but when you do what you think is fair, you should take a look at these 11 factors. General principles of equity is another way of saying, okay, what are the real factors? We talked about the quote-unquote subjective factors that a court must take a look at. we really are talking about 4 factors: the age of the parties, the education of the parties, the length of the parties' marriage, and the income of the parties. These are the real factors. They're objective, they're readily measurable, they're not subjective like lifestyle or needs or fault. Age, education, length of marriage, and income are probably the 4 core most important factors. The older parties are, the higher the education or lower the education, the length of the marriage, whether it's longer or shorter, the income of the parties. If you're older, alimony is more likely. If you're uneducated, alimony is more likely. If you're highly educated, alimony or spousal support is less likely. If you have a short-term marriage, maybe alimony is less likely, or at least shorter term. A really long-term marriage, maybe long-term or permanent alimony. And of course, the income of the parties goes with the needs of the parties. And that really plays a major role. What are the needs of the parties in their present situation? I put number 5 here, the other factors, what I call the subjective factors. That's that list from that prior slide dealing with the past relations and conduct of the parties, the prior standard of living. These subjective factors really play a minor role from a practical standpoint. So we have both a legal answer and a practical answer. The legal answer is you must look at these 11 factors that are also outlined in cases like Parrish and their prodigy. And then you have the real factors, what a court really looks at. And this kicks in, sort of tells you where to focus your time as a lawyer. What about guidelines? A lot of people have heard about guidelines, and they do exist. Guidelines do exist. All right, but there was this case, Mylan versus Mylan, and it's up here on the screen right now on the slide, heard in November 23rd, 2010, and the Michigan Court of Appeals said, listen, judges, you cannot use this rigid formula, a guidelines per se, because every case is different. It doesn't take into account the parties' unique circumstances. So a Michigan judge, their ruling was overturned by the Court of Appeals because they admitted that they used guidelines, all right? A rigid and arbitrary formula. And it's no-no. But here's the key learning, okay? Every judge has guidelines for alimony and spousal support. I would bet $1 on that. Every judge has guidelines that they use. Now, they're not going to admit it on the record. They're going to say we can't use it because the Michigan Court of Appeals has it. But they're always talked about in chambers for some reason. Well, what do the guidelines say? More about these guidelines. This is sort of that battle between the legal answer and the practical answer as it relates to alimony and spousal support. Well, there are 2 software companies, Springfield Publications. Prognosticator is used by many counties, including Oakland County. And I think Wayne County as well. MarginSoft, which is Craig Ross's software. He's a former friend of the court referee out of Washtenaw County. Of course, they're used by Washtenaw County, Macomb County, Wayne County. Sometimes you see using MarginSoft. And these 2 software companies really produce, in the numbers, if you plug in numbers at the age, education, income, and length of the party's marriage, they're going to come out with similar numbers, all right? Similar numbers in terms of what these lawyers' subjective belief that alimony should be based on those objective factors, the age, education, income, and length of the party's marriage. All right, sometimes you see, depending on the court that you're in and what judge you're in front of or what county you're in, local guidelines. And these, of course, are those quote-unquote local guidelines. Judge Lombard out of Wayne County, prior to the Mylan case at least, would always talk about a rule of thirds. What is the Judge Lombard's rule of thirds? You take 1/3 of the difference of the party's income, that's the alimony amount, after deducting child support if that's being paid, and for a length of 1/3 the length of the marriage. So if there's a $10,000 difference between the parties' incomes, and they've been married for 9 years, you have a 3-year alimony award for $10,000 divided by 12, $900 and some odd dollars a month in alimony. Pretty rigid formula. Percentage of excess income is another local guideline. Sometimes judges, I've heard them say, well, have him pay or her pay 12% or 15% of the difference of the parties' incomes. Okay, merely a percentage, and we'll use that for guideline. And for the term of alimony, maybe until pension starts, or maybe for 1/3 or 25% or some percentage of the length of the party's marriage. Equalization of the incomes in long-term marriages. I've seen this in Oakland County with a couple of judges. If you have a 30-year marriage or something long, it doesn't matter. The courts are going to say, all right, wife is going to receive the same amount of money as husband, regardless of the disparity of income, regardless of the age of the parties, the education, the needs of the parties. So it's important to note that you have an experienced lawyer help you that's familiar with both the local guidelines, not official guidelines, but what judges tend to do when negotiating your case. Because if you're negotiating a file and you have a judge that likes to follow a percentage of excess income, and you can negotiate a better deal than that, maybe using subjective factors, well, then you're going to want to take that deal. So experience really does make a difference. All right, at trial, what has to be on the record? Those 11 factors that we talked about. Practically speaking, what happens? Okay, let's talk about some strategies. IRC 71 and IRC 215, that stands for Internal Revenue Code. IRC 71 and IRC 215 says that alimony payments or spousal support payments paid in cash are tax deductible to the individual paying alimony and taxable as income for the individual receiving alimony. And this is important. Now, there's some other factors. It must be paid in cash. It must be for a term. It must be terminable upon death. Okay? It's also important to note that there's nothing in Michigan law that says alimony terminates upon remarriage. Yet we see that in virtually every divorce judgment. That's another difference between practical law and legal law. The law only requires that a court consider alimony. IRS rules require that to be tax deductible, it must be terminable upon death. All right? And from a practical standpoint, every judgment says so. Now, when you're negotiating a alimony award, it's important to note that this is pre-tax to one individual and taxable as income to others. And depending upon that individual's tax bracket, maybe the payor is receiving a 40% credit because they're at a 40% tax bracket, and the individual who's receiving money is paying 15% income tax on it, or vice versa. It's highly relevant in negotiating an alimony amount to understand the tax considerations, how it's taxed to both parties. Now, a court can only order modifiable alimony. In fact, there's a Michigan Court of Appeals case that requires, it's called Staple versus Staple, that alimony awards are always modifiable upon the showing of proper cause and change in circumstance. You have a statutory right under Michigan law to modify alimony. So a judge can only order modifiable alimony, recognizing that there are circumstances that can change in the individual's life. But we often negotiate non-modifiable alimony awards, and that can be advantage to one party or both parties, or it can be advantageous to neither party. Well, what do I mean by that? Well, let's say that you are going to be obligated in all likelihood to pay alimony payments of $1,000 a month for 5 years. Okay, so that's $60,000 over the course of 5 years. And you say, wait a minute, a judge can only order modifiable alimony, and there's a chance I could lose my job in the next 5 years. So I will guarantee to pay you $24,000 now instead of $60,000 over 5 years. And guess what? In doing that, we do a present value calculation, and the value of $24,000, a dollar in your pocket now, after inflation and other considerations, is worth significantly more than a stream of payments. And in fact, this $24,000 that I'm giving you now might be worth $40,000 after you take into account tax affecting the asset, right? Because of IRC 71 and IRC 215, or after you take into consideration the fact that there's inflation, and what we do is a present value calculation in order to determine that. Now, discounting and prepayments deal with the same thing. You essentially say, well, wait a minute, I'm giving you this money now, a lower amount than what the court would order, but I want a discount because it is a guaranteed money. You're exchanging the risk of modifiability for guaranteed payment. Therefore, I want a discount on that money. It's another key negotiation strategy. Sometimes what we do as well is maybe cash flow is more important to an individual than paying alimony, or somebody wants a house, for instance, or to be relieved from debt. So it's not uncommon to leverage a alimony or spousal support obligation in exchange for another party taking on a debt or trading an asset. And once you get into the tax affecting aspects of that, especially as it relates to IRC 215 and IRC 71, you can really get into some complicated calculus. And in some instances, if you have an unsophisticated client on the other side or an unsophisticated lawyer, it's an opportunity to take advantage of the situation. When we're talking about alimony and spousal support, it is so key to understand that it's complicated. And I recognize that it is inevitable that you're going to have questions. We talked about a lot of information here. And quite frankly, I recognize that it's complicated. I want to be here for you. We want to be here for you here at Findling Law. So if you have questions, call us. Here's my direct number, 877-968-7347. It's toll free. You can remember it as 877. It spells out your firm, like YOURFIRM. Call me. We'd be happy to answer questions. Of course, you can email me at daniel@findlinglaw.com. It's right here on the slide on the website as well. Of course, on the website, there's various areas that you can contact us or ask a question directly. I encourage you to do so. It'd be a privilege to represent you. Hopefully, you've learned something here today, and look forward to having the opportunity to meet you possibly in the future as well. Thank you.